Welcome, everybody. Can you all see and hear me?
Yes.
Yep.
Poor souls. Okay, we're going to go ahead and get started. We've got looks like about half of the registrants are in the building, but this will be recorded, and anybody who wants to watch it later certainly will make it available on the Central Section website. So diving right in, welcome to the 2025 legislation update. My name is Jeff O'Neill. I'm a principal planner at Provo and Pritchard Consulting in Clovis. I've been here for almost 22 years and in the profession for almost 25. Um, I generally focus on municipal contract planning, and I am the Central Section's policy and legislation representative. And in that capacity, I meet monthly with the other section ledge reps, along with the chapter vice president for policy and legislation, and other attorneys, and the chapter lobbyist for legislation and policy. And it's my pleasure to bring to you this update of legislation that was passed in 2025, much of which took effect January 1st of this year, but some of which actually took effect last year, and has been in play for a handful of months now. And the goal here is, with a couple of exceptions, not to dive really deeply into all of the minutia of a lot of the bills that were passed, but just to give you a broad overview of the kind of by category, the types of legislation that were passed, and with real brief descriptions of what they're intended to do. We will get in detail to a couple of bills that were passed that seem to have a particularly important effect on what we do, or at least they're purported to. Still remains to be seen. And at the end, we will have the last slide includes, for anybody who's AICP, it does include the code to get the 1 point for certification maintenance. So you can take a look at that. And I have been working on a handout or cheat sheet that kind of goes over brief blurbs about each one of these bills, again, with more detail about some of the potentially more impactful ones. I thought that was going to be ready to just distribute immediately following this meeting, but it should be forthcoming within the next handful of days. And so anybody who is registered for this, we can certainly send that over to you. And we'll also make that available on the Central Section's website. So without any further ado, we'll dive right in. That's me. Okay, so the 25-26 legislative session was a lot of this material was gone over at the 2025 APA conference in Monterey, which was planning at the Crossroads, and I borrowed a lot of information from that presentation to put this together. Although I have done some internal presentations to our own staff for which I elaborated pretty heavily on a lot of the information that we already had from last year. So last year there were approximately 2,400 bills introduced, which was up a fair amount from the previous legislative session. There were 300 directly related to planning, which is down from the previous year. And then there were 900, well over 900 bills that were sent to the governor, and he signed something over 800 of those. Again, most of which took effect in January, but some of which took effect mid to late 2025. So a number of these bills, almost 24 of them, were the result of the Select Committee on Permitting Reform, which was chaired by Buffy Wicks. And that looked at permitting processes across the state and local levels, and it focused on housing, energy, water, and resiliency issues, climate resiliency specifically. They held multiple hearings across the state in 2024, and again, almost 24 of the bills that were passed last year are specifically intended to implement the permitting reform. So by category, we're going to start with infrastructure, services, and fees. AB 417 provided for enhanced infrastructure financing districts, community revitalization and investment authorities, and then post-COVID small business recovery. Bills related to child daycare facilities co-located in multifamily housing, becoming a by right use. As we're all aware, there have been a number of uses that have been considered standard single family, such as small family daycares, certain types of transitional or supportive housing, et cetera. And now a lot of those things are now applicable in multifamily districts as well. Same kind of rules, no taxes, license fees, permits required. It's just considered a permitted use within those zones. There were minor adjustments to the Mitigation Fee Act related to vehicular traffic impact fees, as well as right-of-way dedications and improvements. A couple of two-year bills, meaning that they could be signed this year, even though they were introduced last year. A bill to waive impact fees, local jurisdiction impact fees, not school fees, for affordable rental projects, and then limits on Quimby parkland dedication for infill projects. Items related to climate, energy, and affordability. Reauthorized the cap and trade, which is now called the Cap and Invest program, through 2025. Along with a companion bill to determine how the funding from that will be spent. Creation of a west-wide, which is correct, regional electricity market to help maintain California's electricity generation sustainability. SB 237 allows issuance of up to of not more than 2,000 oil exploration permits each year within Kern County. Again, with the hope of reducing California's dependence on petroleum products from outside the state, especially with what's been going on with closures and so forth just recently now, particularly opportune. And then there was this California Transmission Accelerator Revolving Fund program was adopted, and that also ties into construction of enhancement of the grid and transmission lines for electricity. And that coincidentally also added to the state's wildfire liability fund. The world of wildfire hazard mitigation. There were 4 bills specifically adopted related to wildfire hazard mitigation. Again, these were largely spurred by the tragedy in and around Los Angeles from last year. Although, as we're all aware, we do have some tragic fire situations within the central section also. As an aside, in addition to actual legislation that was passed, there were many executive orders and emergency declarations made specific to the Los Angeles area. Obviously, none of those would apply around here, but certain of these wildfire hazard mitigation bills could have some effect here. Going right along with post-wildfire recovery legislation. As you can see, three bills here generally intended to address wildfire hazard severity zones, safety areas, how approval of development projects must be streamlined following local emergencies, kind of expedited building permit approval, those sorts of things. Just generally intended just to streamline reconstruction following these disasters. In the world of long-range planning, we had a host of bills related to general plan and judicial challenges. Certain things that don't affect us related to sea level rise plan, not specifically because of our geography, obviously. Sea level rise plans, Coastal Act modifications, the establishment of the Bureau of Environmental Justice and Community Air Monitoring. And then, interestingly, SB 299 was supposed to be a 2-year bill, but it made it through the process during the first year. And that is related to lodging in hotels and motels as a result of disasters and giving individuals certain rights to remain within those facilities while they're awaiting housing reconstruction. Following up on long-range planning, certain things that are specific to general plan updates. Local Electrification Planning Act was codified. So every jurisdiction with a population greater than 75,000 has to adopt an electrification plan, decarbonization plan, community energy plan, or other similar plan, and integrate that into its general plan. So at least unlike certain other laws where we have mandated general plan updates or significant amendments, this one gives jurisdictions about 4 years from the time it took effect to get going on that. So the plans have to include opportunities for zero emission vehicle fueling infrastructure, removing barriers to installation of those kinds of facilities, giving opportunities to expand charging locations for the public, strategies for electrification and decarbonization of buildings, and locations where grid infrastructure upgrades are necessary. That kind of places a large onus on these local agencies, most of which are not involved in the production, generation, storage of electricity, since we generally rely on our private utility providers for those sorts of things, with some exceptions. 4 bills were passed related to accessory dwelling units, most of which revolved around, as we've seen the trend over the last 10 years or more, streamlining the approval processes, removing barriers to construction of ADUs, removing local agencies' abilities to regulate against ADUs. The common theme that we've seen, like I said, over the last decade or so, again, in an attempt to accelerate the and streamline and simplify the creation of accessory dwelling units to address the statewide housing crisis. Similarly, density bonus provisions have been modified, again, to try and spur the development of affordable housing. I know we all love doing our annual progress reports, both for the general plan and for our housing elements. So of course we have more laws that help us figure out how to struggle through that. Now we have to address converted affordable units, rehabilitated units, have to, for the Permit Streamlining Act, we need to create centralized application portals for housing development projects. We're supposed to begin addressing unlawfully restrictive covenants for housing developments. Typically, especially if they're private covenants, CCNRs, the local agencies don't really dive into that. Now we have to address emergency shelters within the housing element in a different way. And then in addition to coastal resource development permits, not anything that really affects us in the central section. A whole lot of stuff related to regional housing needs allocation and the housing element. As we're well aware, starting really with the 5th cycle and then becoming painfully obvious in the 6th cycle, the requirements being put in place by the legislature and the governor and then being implemented by HCD are becoming ever more onerous, time-consuming, and costly. Some of what went into effect related to this kind of places restrictions on HCD and how it performs its review and assessment of housing elements. Although I would have strongly imagined that it's not really going to make doing the housing element any easier or simpler. It's still going to be very costly. It's still going to be very time consuming. However, I think that at least the legislature has seen that it's extraordinarily painful for a lot of public agencies to get through their housing element process timely, and hoping to streamline it by placing a little bit more burden on HCD to justify why it does and does not accept housing elements as being substantially compliant. More housing streamlining. Again, coastal development permits doesn't affect us. Provisions for housing at higher education facilities specifically related to student housing, which didn't make it into the bill, but there were parking changes, um, adaptive reuse, tax incentives by right approval, community college housing, now written in to be exempt from local zoning regulations, which a lot of public agencies had treated um, certain community college activities as being exempt, but a lot of them were not. Now that's been addressed such that community college housing is exempt as well as an agency of the state. Allowing more housing development project types in commercial areas, expanding urban lot split sites into historical districts to lots that are not individually listed. And it's an interesting concept throughout the state how much we see what an impact SB 9 has or has not had related to the urban lot split provisions. Some public agencies see multiple parcel maps for urban lot splits just very frequently, multiple times a month. Others have not had a single application for them. So we'll see if this has any effect since it's specific to historical districts. But SB 79 was a very large, important bill that took effect related to housing development, specifically transit-oriented housing development. I didn't include a lot here because it only applies in I believe 11 counties, counties that have more than 15 passenger rail stations. So it's was specifically intended to apply to regions that have light rail, BART or Metro or similar. But I felt it was at least worth mentioning because there's the potential for expansion into areas that do have other transit options. CEQA, as far as how laws related to housing that are specific to CEQA, that's not even what that's supposed to be. That's not supposed to say housing. Sorry about that. Probably just the first of many, many mistakes. These are CEQA provisions that specifically relate to geothermal projects and to non-motorized recreation and public access. Okay, so now we're going to get into the ones that involve a little bit more in-depth discussion, which are the companion bills largely related to the budget, AB 130 and SB 131. So these have kind of been hailed, or they were hailed at the time, as the most sweeping changes to CEQA since its inception. The things that were going to fix everything that was wrong with the CEQA process and the streamlining of projects and so forth. Before we get to that part of it, though, AB 130 does include a component related to VMT mitigation, which allows the lead agency to mitigate VMT impact by funding or otherwise facilitating VMT efficient, affordable housing or related infrastructure projects. And it creates a statewide fund to implement transit-oriented development specific to VMT impacts. And it allows either the lead agency or the project proponent to pay into the fund. And then interestingly, HCD gets to distribute the funds to affordable housing development itself, or to infrastructure projects related to affordable housing that would reduce vehicle miles traveled. So then the first one here that's related to CEQA is a new / modified infill development exemption, and it's a statutory exemption, unlike the guidelines section 15332 categorical exemption that we're so used to. This one is, like I said, it's not in the guidelines, it's in the CEQA statute, and it applies to projects up to 20 acres maximum size rather than 5. Although if the project also subject to the builder's remedy, then the project site is limited to a maximum of 5 acres. So this expanded the definition of infill, which wasn't really defined originally in 15332. And then it kind of got defined to include something that was surrounded or that bordered urban development on 75% of its boundary. This includes um, a couple of other definitions related to oddly shaped parcels, related to urban development, not necessarily abutting the project site, but within a buffer zone around the site. So in theory, more projects might qualify for this exemption based on the relaxed stringency or narrowness of the definition of infill. There are minimum density requirements depending on whether it is in an urban or suburban or rural county or within a city. Has enhanced tribal consultation requirements. It does require a phase 1 ESA as part of the exemption process. It can require prevailing wage for construction workers. Interestingly, it's only any project that is subject to this is only required to be consistent with either the general plan or zoning. So in the case of projects where we're looking for this exemption, if the zoning and general plan are inconsistent, the zoning can actually supersede the general plan if it facilitates construction of the project. And then similar to other types of streamlined projects, if it is within the coastal zone, a prime farmland, wetlands, very high fire hazard severity zones, fault zones, etc., this exemption does not apply. So additionally, AB 130 looked at a bunch of legislation that had been passed within the last handful of years that had sunset dates built into it and removed those sunset dates related to the 5 hearing limit, determinations of historic value when an application is deemed complete, vested rights for preliminary applications, the definition of when something has been determined to be application determined to be complete, providing fee and exaction estimates within 30 days of receipt of a preliminary application, exhaustive lists of incomplete application items, and then reduced approval times following CEQA adoption or EIR certification. So SB 131 exempts most rezoning actions intended to implement housing element programs from CEQA. That was always a concern wherein if we're going to do rezoning to be consistent with the general plan so that we're providing proper site inventory, well, we've still got to go through the CEQA process to change the zoning of those sites or to make zoning text amendments or anything like that. Now those processes are exempt. Now, of course, any development of the site is not exempt, but at least the zoning action necessary to facilitate it is exempt. The other kind of what was purported again to be a sweeping change to CEQA was the almost exempt exemption, or the single factor exemption, or whatever we want to call it. So if somebody proposes a housing development and you're reviewing it for exemption and it almost meets the criteria, and I'm sure we've all come across that many, many times, and then had to fight with the project proponent about, no, sorry, this is really not exempt. It almost is, except you don't meet this one criterion. So we've got to do an initial study, and who knows where that's going to go. So if you go through the list of qualifications for a particular exemption and it meets all of them but one, then you still have to prepare an initial study, but the rest of the project effects are exempt other than examining that one criterion that it didn't meet under the exemption. So more on that on a subsequent slide here, but it also, if the initial study results in the determination that an EIR is necessary, then that EIR, which still examines only that one effect, does not have to examine alternatives, nor does it have to look at growth-inducing effects. So that is actually kind of a handy streamlining tool. So this exemption applies to any statutory exemption. So anything that's under Public Resources Code and then a number of common categorical exemptions, including, as you can see down there, we've got the parcel map exemption, we have the infill development exemption. It also applies to other less common categorical exemptions. And then interestingly, it also applies to CEQA guidelines section 15300.2, which is the exceptions to the exemptions section. So a couple of examples. Somebody's proposing a project and you're looking at it for exemption under 15332, the infill development. There are a handful of criteria under that exemption, including that the project cannot have a significant effect on traffic, air quality, noise, or water quality. So you go through, and a lot of agencies tend to do kind of a reduced environmental checklist for 15332 exemptions anyway, because it does have a lot of qualifiers to it. So you go through that and you just determine that the project could have VMT impacts. But the other things, nope, no air quality problems, no noise, water quality problems, and it meets all the other criteria for an exemption under class 32. Then you still have to prepare an initial study, but it only looks at traffic at the exclusion of all of the other environmental resource categories. And again, if it did result in significant effects, and an EIR was necessary, again, the EIR would look only at traffic. So then under the 15300.2, so that contains a list of criteria that preclude using categorical exemptions. If it's a hazardous site, if it would affect scenic highways, if it would have cumulative effects, if it would affect historic resources, and a handful of other criteria. So just picking historical resources, if the project is otherwise exempt under, say, 15332, it meets all of those categories, but then you're looking at it for the exception, and it turns out it might have an effect on a historic resource, then that's the only criterion that you look at in the initial study, and the rest of the project is otherwise exempt. More under SB 131, there's a provision that relates to disadvantaged communities' utility systems. So if a water system serves 15 or more connections or 25 residents on a year-round basis, it can qualify for this. It exempts certain sewer systems where the treatment is inadequate, does not apply to irrigation projects or growth-inducing projects. Any project undertaken by a private entity still has to pay prevailing wage. And then it contains similar exceptions as those contained in guidelines section 15300.2. And this expires, it does have a sunset date built in, 2032. There were additional utility exemptions, community water systems that are funded by this very specific act of 2024, or the Safe and Affordable Funding for Equity and Resilience program. However, the project cannot otherwise include any construction activities, has to result in long-term benefits to climate and biological resources, and it includes procedures for protecting the environment. So in having talked about this with other planning consultants and with our engineering staff who work on projects under these funding sources, we really haven't been able to piece together how this helps. But we do know that it expires at on the first day of 2030. So SB 131 further exempt wildfire risk reduction projects, linear broadband deployment within existing rights of way, updates to the state's climate adaptation policies, public parks and non-motorized trails funded by the Safe Drinking Water Act that I just mentioned, which is interesting because if you go back to that, it includes construction activities, but those are specific to water apparently. It exempts daycares, rural health clinics, and certain advanced manufacturing facilities, and then high-speed rail maintenance facilities and stations. So, other things that are a part of the legislation, SB 684 and SB 1123 kind of go along together. So local agencies are required to approve maps containing up to 10 residential units of as small as 600 square feet on multifamily zone land. Now, SB 1123 modified that, which precluded ADUs or again, more legislation intended to prevent cities from approving, intended to prevent cities from approving ADUs, because they were sure we'll process this 10 lot subdivision, but you know what? You can't have any ADUs because those would count against that 10 unit minimum. So the legislation was put in place to remove that aspect. It allows the use of vacant single family land. Now, interestingly, on the multifamily land, it does not have to be vacant, but the single family land does have to be vacant, and you can subdivide down to 1,200 square feet. Lots are not required to comply with any minimum frontage requirements. It does require units to be built on the lots before they are sold, so as to prevent just land flipping, getting subdivisions of these 10 lots approved and selling it and walking away. You do actually have to construct the dwellings prior to selling the lots. So then, you may recall AB 98 from a couple of years ago was kind of a big kerfuffle. It mandates that warehouse standards for logistics use developments, including design standards, parking and loading, landscaping, entries and signage, and then building and energy efficiency standards. And logistics use was defined to mean a building used for storage and later movement of cargo that doesn't involve on-site retail and primarily involves large trucks. So we kind of all know what kinds of buildings and uses that entails. So AB 98 requires applicants to develop a truck routing plan and then required all jurisdictions to update the circulation elements of their general plans to identify truck routes and post them with conspicuous signage, identify truck parking and idling locations and signage, and it authorized the Attorney General to fine non-compliant jurisdictions up to $50,000 every 6 months. And all cities were required to have this done by the end of 2028. And within the warehouse concentration region, which is basically the Inland Empire, it was supposed to have been done by 2026. And there was a huge outcry against that because apparently the legislature doesn't understand what it takes to amend a general plan in that kind of significant manner, both time-wise and cost-wise. So the companion bills, SB 415 and AB 735, which just went into effect, changed some definitions. They allow most jurisdictions, which are the jurisdictions outside of the warehouse concentration region, to adopt ordinances rather than amend their general plan, which was actually a huge push by the APA chapter to the legislature, a huge lobbying effort. Which at first didn't look like it was going to happen, but then some people finally saw the common sense there. It requires logistics uses to be accessible via major streets or streets mainly serving commercially oriented uses as opposed to driving through residential neighborhoods or similar. It gives the attorney flexibility in taking action if a jurisdiction is making a good faith effort to comply with the requirements. And then interestingly, it also requires the Department of Highway Patrol to train local agencies about enforcing commercial vehicle laws. So that kind of wraps that up. I guess I went through it faster than I thought I would. I guess it pays to do a run through before you make a presentation. Does anybody have any questions? Okay, I'm seeing and hearing no questions. Um, Sorry for making you sit through that again, but I'm glad everybody could make it. And again, here's the AICPCM credit code for logging your 1 unit. And if you do have any questions in the future, please feel free to reach out either to me or to another member of the board. And we will be sending out the statutory cheat sheet in the very near future. So oh yes, sorry. Yeah, both the recording of this for what that's worth, and the PowerPoint itself in PDF form will be made available on the Central Section's website. So we'll also get that information out to you very, very soon, within the next few days, presumably. Okay, well, I appreciate everybody signing up and attending, and we will see you in 2027. Thanks a lot.